Hello, my name is Emmanuel Yeboah. I'm the plaintiff for this. I'm the plaintiff of this case. I stand before you today representing Justin and Paige Cerny, two homeowners who entered into a contract with Masco Insurance Coverage Company. Based on the presentation made by its agent, Molecule, this case centers on three key issues: misrepresentation by the agent, the enforceability of the arbitration clause, and the fairness of the arbitration contract. Today, I will show you why my clients are entitled to pursue relief, either through arbitration court or in court. First, let's address the issue of misrepresentation. Justin and Paige purchased their home insurance policy with a clear focus on protecting their home from a sub-pump failure. They made it explicitly known to Molly that weather-relatable damages, particularly from a failed pump slump, was their primary concern. Paige asked Molly whether an additional rider was needed for the coverage, and Molly assured them that it was not. Molly's assurance was a critical factor in their decision to purchase the policy from Masco. The term is believed, based on Molly's word, that they were fully covered in the event of sub-pump failure. When the sub-pump failure failed during a storm, causing $20,000 in damages to their crawl space, they were shocked to find out that their claim was denied because the policy lacked a sub-pump rider. The very coverage they were assured that they didn't need turned out to be an essential. Molly's assurance were not only misleading, but they directly induced my client into purchasing an insurance policy that failed to protect them as promised. This misrepresentation by Masco agent is the heart of the dispute, and that is what brings us here today. Second, the arbitrary clause at issue here does not preclude my client from seeking relief. Masco argues that this arbitrary clause prevents my client from taking action, whether through an arbitrary or litigation. However, Your Honor, this clause is not as compromising as Masco claims. The clause specifically limits dispute coverage issues. And here's the key point: misrepresentation is not just a coverage dispute, it is a tort. When Molly misrepresented the policy to my client, that was fraudulent misrepresentation, a tort that falls outside the scope of this arbitration clause. The clause only pertains to determine whether coverage exists under the term of the policy. Fraudulent misrepresentation is an entirely different matter. It concerns how my client was induced into signing the contract in the first place. In fact, tort claims like fraud are generally not subject to arbitration unless explicitly stated, and that is not the case here. The language of the clause does not cover tort-based claims. So this court has every right to hear the case, or alternatively allow arbitration for the misrepresentation claim. Masco cannot use this clause as a blanket to shield itself from the consequences of its agent's action. Third, let's talk about the unconscious liability of the arbitration clause in the adhesion contract. Your Honor, the insurance contract is a textbook example of an adhesion contract. My client had no power to negotiate its terms. They were presented with a standard, take it or leave it policy, where Moscow dictated other provision, including the arbitration clause. They had no ability to bargain or change any of the contract language. And an arbitration clause that effectively stripped consumers of their right to seek relief is not only an unjust, it is unconscionable. In this case, the clause bars my clients from going to court, even when the fraud is involved. The contract essentially says that my client must accept Moscow's decision, no matter how flawed or fraudulent the circumstance might be. This put them in a situation where they cannot challenge an unfair denial, and it denies them access to justice. Courts have recognized that arbitration clause is an adhesion contract, particularly those that are one-sided or unduly harsh may be unenforceable. This is exactly such a case. My client did not have the ability to negotiate fair terms, and now Moscow is using this arbitration clause to avoid any accountability. Allowing this clause to stand will leave my clients without any remedy for the injustice they have experienced. Your Honor, we ask this court to allow my client to either pursue their claims through arbitration or alternatively in court. We have said that the representation by Moscow agent is at the core of this dispute, and it must be resolved, whether through arbitration or litigation. Arbitration clause does not apply to tort claims like fraudulent misrepresentation. And this court has authority to ensure my client receive a fair hearing. Moreover, this arbitration clause is unconscionable in the context of an adhesion contract and should not be enforced, as it leaves my client with no value of justice. Moscow made promises to my client that it failed to uphold. My client will live on those promises only to be denied the coverage they were assured. Your Honor, we urge you to grant my client the opportunity to pursue their rightful claim. Thank you very much.